Homeowners associations. Love them or hate them, right? They're supposed to keep property values up, but what happens when the board makes a decision that just feels wrong? Well, we're about to jump into a classic showdown. One single resident against his entire HOA board. And it's all about a new gym that ended up in court. So this is where it all kicks off. This is a direct quote from the official petition filed by the homeowner, a guy named John W. Griggs. And his argument was pretty straightforward. He said the HOA board at his condo building went ahead and approved a whole new fitness center without getting the majority vote from all the homeowners, which, if you ask him, means they flat out broke their own rules. All right, so let's set the stage. On one side, you've got John W. Griggs, just one homeowner. And on the other side, the entire executive Towers Homeowners Association. You know, the board that runs his whole high-rise condo? This is your classic David versus Goliath situation, but for an HOA. So how did this whole lawsuit even get started? Well, it all goes back to this one commercial space in the building, Suite 7. For months and months, it was just empty. No tenants, which means no money coming in for the community. And as you know, an empty storefront is never a good look for any property. So the HOA board gets an idea. They're thinking, hey, why don't we turn this empty, useless space into something awesome for everybody? You know, a modern new fitness center. And look, on paper, that sounds like a fantastic idea, right? A total win-win for all the residents. But of course, it was not that simple. Okay, so let's get back to Mr. Griggs's side of things. For him, this wasn't really about whether a gym was a good idea or not. His whole case was built on one thing, that the board violated its own rules. The big, important governing documents, the CC&Rs and the bylaws. He said they broke the rules in two very specific ways. Okay, violation number 1. He claimed that by fixing up Suite 7, the board did what's called a structural alteration to the building. And according to the rule book, that's a big no-no. It's something they absolutely could not do without a vote. And here it is, the exact wording right from the HOA's own rules. It seems pretty crystal clear, doesn't it? There shall be no structural alterations without the prior approval of a majority of the owners. Mr. Griggs's point was simple. The board never got that vote. So case closed, they broke a fundamental rule. All right, on to his second point. And this one was all about the money. He argued that this whole project was a capital expenditure that blew past the board's spending limit. And, you guessed it, that also would have required a vote from the homeowners. And here's the other crucial piece of the puzzle. We're talking about a specific number. The bylaws say the board cannot approve any capital spending over $5,000 without getting a 2/3 vote from everybody. So really, the whole case comes down to two simple questions. Was this a structural change? And did it cost more than $5,000? Okay, so now let's flip the coin and look at the HOA's defense. The board is saying, whoa, hold on a minute, we didn't break any rules. They saw this as just making a smart, practical business decision that was actually going to help protect everyone's property values. So the board laid out its case. They said, look, this suite was empty for over 6 months. We tried to find a commercial tenant, we really did, but nobody was biting. The area just isn't a hotspot for that anymore. And, this is a big one, they pointed out that their building was literally the only high-rise in the neighborhood without a gym. Real estate agents were telling them this was actually hurting sales and dragging down property values. Now, the board did admit, okay, fine, we didn't hold a big formal vote, but they did send out a survey to see what people thought. And check this out, out of 160 apartments, almost 100 of them sent it back. And the results? Overwhelmingly in favor of the gym. We're talking a 3-to-1 margin. So the board basically argued that with that much support, a formal vote was just, a formality. And then we get to the magic number, $4,000. That's what it cost to fix up the suite. Now remember that spending limit we talked about? $5,000. So this $4,000 figure, that's going to be really, really important. So there you have it. You've got the homeowner on one side, sticking to the absolute letter of the law. And then you have the board, arguing for common sense and what the owners seem to want. The whole thing had to be settled in a formal hearing. It was all up to a judge to make the final call. And make no mistake, this wasn't just some angry meeting in the lobby. This became a real formal legal case. In January 2016, Mr. Griggs and the HOA board both had to go and present all their evidence and their testimony in front of an administrative law judge in Arizona. This was the real deal. So it all comes down to this, right? Who was actually right, according to the law? Did the board go too far? Did they overstep their authority and just ignore a required vote? What do you think happened?
And the verdict was in. Drumroll, please. It was a clear win for the HOA. The judge dismissed the homeowner's petition completely. The ruling was that the board did not overstep its authority. But the biggest question is, why? How did they win?
And this is where it gets really interesting. The whole case, the entire decision, came down to the super specific legal definitions of those two phrases Mr. Griggs was banking on. It's really a perfect example of why the exact wording in these HOA documents is just so incredibly important. Okay, let's break it down. First up, structural alteration. So it turns out that legally that term means something pretty major, like a significant change that basically creates a whole new structure. The judge looked at what the HOA did, taking down some temporary non-load-bearing walls, putting in a new floor, and said, nope, that's just cosmetic. It didn't touch the building's bones, so it wasn't a structural alteration, which means that rule about needing a majority vote didn't even apply. All right, now for the second term, capital expenditure. We know the renovation itself was only $4,000, so that was safely under the $5,000 limit. But what about all that expensive gym equipment? Well, this is where the board was actually pretty clever. They didn't buy it, they leased it. The judge decided that since the equipment was leased, not purchased, it didn't count as a fixed asset. And those monthly lease payments, they don't count as one big capital expenditure. So once again, the board stayed under the limit. Pretty smart, huh? So here's the bottom line, the big takeaway. The board won this case because they knew their own rulebook inside and out, down to the precise literal definitions of the words. They made a change that, felt pretty big, but technically it wasn't structural. And they set up the spending so it technically wasn't a capital expenditure. In this battle, the specific language in the bylaws was absolutely everything. And all of this kind of leaves us with one big final question, doesn't it? This case proves that an HOA board, if they're smart about navigating the exact wording of their own rules, can actually make some pretty huge changes without needing a full vote from everyone. So it really makes you wonder, have you ever read your HOA bylaws that closely? Does your board have way more power than you even realize?